have the patience of Job and the wisdom of Solomon. Thank you for your patience so far. When Little's got through his things, he says, quote, if we would have gotten into a tussle, he would have probably go for one of our guns. And he did a walkthrough out there, remember, and he said, I had my hand on my weapon, but it was over before I could pull it out. You know, what's Kerrick left home today? He left home to come to court like he's done the last 22 days. Does he go home tonight? Does he go home tonight and carry a really very bad one? He's a 15-month-old son. 4 days after this incident happened, you know, when you get older, you don't have the ups and downs you do when you're in high school. When you're in high school, you get your first car, get a job, get a date for the prom, you're really happy. When you get older, those days aren't around anymore. For those of us who are parents, it's the best time of your life when your husband comes to you, or you go to your wife and she tells you, we're going to be a parent. Is he going to be a parent with no one? Or is no one going to see his dad on the visiting days at the Department of Corrections? It's not about sympathy. It's about what this man, as a father and as a husband, did September 14th, 2013. Let's look at Wes's training. You heard what he said he was trained. And folks, before we go into his testimony, he did not have to testify. His statement's already in. Why put him through the cross-examination Ms. Postel walked him through for 3 hours? Because he wanted you to hear from him. Firsthand, what he did that night, the reasonable actions he took to protect himself from serious bodily injury or death, and his fellow officers. You heard his PRDs. You heard him saying, add me to the call. He ran lights and sirens. You saw his NVR. You heard what happened when he got to Sarah McCarthy's residence. He walked up there. He shined the flashlight. Didn't see anything wrong with the house. It appeared to be secure. Did he walk all the way up here to this exhibit and say, well, I see the bumps there, and I see the indentations there from the alleged breaking? And no. He said everything looked secure. And I heard some shouting in the distance. And the state says, well, he was looking for Max's house. Max's house is nowhere near down here. The person who was down here had no business here. He was fired in response to Lynn's case. He backpedaled. He gave commands. You heard those commands. You heard them like crazy. Stop, stop. Let me see your hands. Let me see your hands. And he ends up in a ditch. This is what his uniform looked like. Covered in mud. This is what his duty belt looked like that the state didn't even seize from. Why not? Don't you want to know all the evidence? The state didn't seize this from Officer Kerrick. How does that work? Mud from the ditch. He's there fighting for his life. You heard the commands he gave. Choices. Again, Mike Green talked about choices 2 weeks ago. He voluntarily gave a statement to CEPD. He gave a voluntary walkthrough out there in CEPD. And Teresa Postel, for 3 hours, cross-examined him to the nth degree. Could you humor me a minute? Think of the worst day of your life. If you close your eyes for just 5 seconds and think of the worst day of your life, can you do that for us, please? Thank you. I'm not going to ask you what it was. Do you remember where you were when it happened? Remember where you were when 9/11 hit? Did you have a green shirt on or a blue shirt? What day of the week was the worst day of your life? Was a friend with you? Did you drive the car and walk to work? Were you working that day? You don't remember nitpicky minor details when you just experienced the most tragic event you'll ever go through. And they're going to come up here and say, well, he told you it was 10 feet, 3 to 5 feet. 10 feet, 3 to 5 feet is within 10 feet. But on the important details of what happened, what he saw, what he felt, what he heard, he was absolutely rock solid. You heard him up there in tears. Almost 2 years later, he can't talk about it without getting emotional. It's an emotional event. It's like going through 9/11. It's like losing one of your parents. It's the worst day of your life. Wes Kerrick lost his mom at 4 years old. He had to go to work to support his family because his dad was disabled. That's the type of person that was proud to wear a Charlotte police uniform. And on the witness stand, when Teresa Postel was cross-examined, she says, where's the citizen directives? And Officer Kerrick looked at her, and you notice what, she was beaten down on, okay? Every question, yes ma'am, no ma'am. Where's the citizen directive? And he says, ma'am, I don't know any. Folks, there are citizen directives. When you got your jury summons for July 20th, you came here. When you drove to the courthouse today, you stopped at the red light. When a police officer is in the presence of a cop, you don't run. Everybody has citizen directives. You get pulled over for a traffic offense. You may not like it, but you have a duty to pull over. You can file an internal affairs complaint, call your supervisor, sue them for whatever. But you have to respond to the lawful presence of police officers. You don't run. That's a citizen directive. That's a citizen directive. You have a right and have a duty to comport with the CMPD officers and any officer when they come up, especially an officer approaching someone who's a suspect when they first degree burglary. You see a red herring. A red herring is something that misleads you or a distraction from a relevant event. Don't be fooled by the nitpicky cross-examination of the state. The major events of what he saw, what he heard, what he did was absolutely consistent. And he got up there and told you that a week and a half ago and withstood 3 hours of cross-examination. Unarmed is not harmless, and a body can be a weapon. He told you why he wanted to be a police officer, that he worked at Best Buy, he worked his way up. This man wanted to be a police officer so bad, he was a dog catcher. You can call it animal control all you want to. He was a dog catcher for a year. And he did great there. He heard his supervisor, Tracy Kirshner, came in and said, I was hated to see him go. James Wilkerson, the EMT, testified. He says, yeah, he was hit in the jaw and saw the edema. Will Parks, SWAT team guy. Again, they didn't call him, we called him. Fourth officer on the scene, he told you my DMVR was full because we had problems with it. Again, you heard Officer Kerrick's explanation of the DMVR. It was full. And it wasn't full. I didn't want it to be looking out in space somewhere when I was thinking you were full. He didn't know he was going to have this confrontation with the home invasion suspect. He came on and he handcuffed the suspect. We didn't handcuff him. Will Parks did, the tactical SWAT officer. He said that tasing a firearm was okay. He separated Wes from the affray. Go over there, get away. He didn't see any blood splatter on Wes Kerrick. His statement, folks, came in and said he heard Kerrick over the radio. After the call, he arrived and made a left-hand turn on Pool Creek Road. He already parked his car. He says he was continuing to pull up. He was looking at Little to make sure Little had his taser pointed out. 2 red dots being illuminated. By the time he put his vehicle in park, the suspect was charging and advancing toward this officer. Revved up. Said he was, get down. Heard Kerrick say, get down, get down. Said he kneel, fired the taser. Suspect ran in his direction, got out of his car and ran around there. Lost all visual sight. Recall seeing Kerrick and the suspect behind the ground. Heard him say, get down a few times. Heard someone say, get down a few times. Demonstrated how he was on the ground and trying to slide away, and the suspect was still coming at West Kerrick. 2 other officers there had a front row seat to this, and one of them the state didn't want you to hear from. He described the suspect as being on his stomach, grabbing Officer Kerrick's lower legs, calling at Officer Kerrick in a defensive mode, trying to move back while firing. That's what this officer was faced with. He got up that day to go to work. He was in the team office when he had me, the call went out. You know, I was in the team office, he heard him testify. He wanted to go in and ask for a day off. But yet the 5 words that will haunt him forever. And me. Neil described seeing the suspect's head drop down, and Ferrell made what he said another lunge. We fired 2 more shots. Quote, I mean, that joker looked like he was in a zombie state. Looked crazy. Might have been on bath salts. Observe the right side of Kerrick's mouth bleeding. Reputation. What's his reputation? He's a nice guy. Dave Cotier told you to testify. He taught Mike Compagni Reali-Tea, the professor and the student. He told you he served his country in Vietnam. He was a military man. He was a U.S. Marine. Joined the National Guard. He's testified in 151 cases in 42 counties. Wrote 16 articles. They were old articles. Okay, he's an author. How many articles did Mike Compagni wrote? He reviewed over 8,000 pages. The state said, well, there's 21,000 pages. Did you interview the phone log records? What would that tell you? Nothing. Mike Compagni interviewed about 4 or 5 or 6 or 7 people. He didn't read 8,000 pages that Dave Cotier read. And he told you, and he came in and said, I'm familiar with CMP procedures. I'm familiar with BLET procedures. And to have this man reholster his weapon and go hands-on was against BLET and CMPD policies. He also told you about reactionary gap, how long it takes an officer to react to something. The same thing that's in Kip White's video of the suspect advancing 30 seconds, 30 feet in 3 seconds. And he also, based on the question here from the state, told you about the number of shots. You shoot till the threat is negated. You shoot till the threat is negated. Eve Ross. Again, the state didn't call her. Eve Ross, he told you, ladies and gentlemen, that DNA is like a fingerprint. It's better than a fingerprint. Where was DNA found? DNA's down right there. Grab it again. And we know the DNA was exactly 1 in 2.32 trillion. It's Jonathan Ferrell's DNA. And that goes back, ladies and gentlemen, to the photograph that we've all talked about, our exhibit, that Dr. Owens told you about and showed you and drew you. Grabbing the firearm. Eve Rossi told you a lot more. She told you about blood. This is State's Exhibit 61. This is the airbag. Blood came from Jonathan Ferrell. She told you about blood coming here from the door. We'll talk about this a few moments ago. Blood came there from the suspect. Right there, trying to grab that. That's what Officer Kerrick told. That's what he told the officers of the state. That's what he said He was lunging and grabbing for his weapon. DNA was found on Wes Kerrick's uniform. We know that. We know that because of what she told you. She said that near the muzzle, we talked about the firearm, on his right boots was Jonathan Ferrell's DNA. Where else was it found? It was found on his pants. It was found on his shirt, out here in this area. You know what else was found on his shirt? Officer Wesley Kerrick's own blood from being hit in the mouth, left hand, DNA under his fingernails, right cheek of Wes Kerrick. He had blood on his shirt. The state asked him, did you see any blood on you? Folks, you're in a blue uniform. Uniform of Wes Kerrick. His blood and the suspect's blood are all over the floor. And that right there, ladies and gentlemen, sums up where Jonathan Ferrell was. He was within arm length of Wes Kerrick. He was coming up, and all the testimony is he's calling at him. He's trying to hit him like that. He does strike him. Trying to obtain what Wes Kerrick told him was his firearm. And again, we know that's his blood because Eve Rossi said the chances of that are more than what's the population of the free world, of the world. Folks, Judge Irwin's going to tell you in a few minutes about the presumption of innocence. When he tells you about the presumption of innocence, he's going to tell you basically, and these are my words, not his. Remember when you filled out your jury questionnaire and said, are you married, divorced, whatever? You got the status to check. His status right now, as he sits here today, is presumed to be innocent. That status doesn't require any proof. It's enough by itself to find somebody charged, not guilty. He kind of is shrouded with that presumption of innocence. Judge Irwin is going to tell you the burden of proofs on this table by the highest burden there is in the free world. That burden never shifts. They have to prove every element of the charge beyond a reasonable doubt. And they also have to disprove self-defense of Officer Kerrick himself or defense of others beyond a reasonable doubt. What's burden of proof mean? If any of you are sitting here and looking at Wes Kerrick right now, and you're looking at him, you're trying to be the six blind men in India, and you're trying to put together the pieces to find the truth, and you're sitting there looking at him and trying to evaluate this case, if you think he may be guilty, might be guilty, if you think he's probably guilty, ladies and gentlemen, that's not beyond a reasonable doubt. The reasonable doubt is the highest burden there is in the free world. It's not beyond all doubt. You're probably going to hear that. That's true. But it's the highest burden of proof. Panthers beat the Bills 25-24 for Saturday night at exhibition game. Is that beyond a reasonable doubt? No. It's got to be all in. If you have any doubt at all, it's a reasonable doubt.
Ladies and gentlemen, I'm going to give you instructions about the law and the law. Those instructions regardless of what any attorney might choose to argue.
Thank you, Honor. Ladies and gentlemen, the jury instructions the judge has, he's going to give them to you in a few minutes. He's also going to tell you this instruction. He's going to tell you that evidence was offered concerning Reali-Tea and CMPD standards. The instruction says these standards are not to be considered as legal standards that you apply in reaching your verdict. You may consider them in determining whether or not the defendant used more force than reasonably necessary at the time he discharged his weapon. My interpretation is as counsel for Randall Kerrick says, you're never going to hear the judge say, if he violated policy, he's guilty. You will never hear that. Poor judgment, bad judgment, good judgment does not equal guilt beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense. The judge is going to tell you this, arising out of some or all the evidence. Would you hesitate to act? That's reasonable doubt. Would you buy a used car from this table, given what they've not shown you and withheld from you about the witnesses? If you have more questions than answers, you're not fully satisfied and entirely convinced. You're never going to hear a directive violation is illegal. You're never going to hear the words in Judge Irvin's instructions, aggravated, active, aggression. And you're going to never hear, he must come forward and prove something to me. You know, when an officer gets a phone call, they are required to act. They can't turn their back and say, I'm not going to answer the call. We cannot go back and look. We can't Monday morning quarterback or give 20/20 hindsight to what was in Officer Kerrick's mind. Was it reasonable, given the facts and circumstances he was faced when he uttered those words, add me to the call? You know, next week, probably Chrissy will be in another courtroom. His table will be back to Raleigh. Judge Irvin will be back in another courtroom. Mike Green will be here in another case. There are three entities in this trial that are important. One is the Ferrell family. They have acted with class and with dignity the whole 5 weeks we've been here. They suffered a loss. They suffered the loss of a loved one. This case will stay with them forever. He'll stay with this family when he was there. He'll stay with Wes. He'll stay with Carrie. His father-in-law, mother-in-law forever. He'll stay with you folks forever. It's my guess to me this is probably one of the hardest decisions you as a collective body are going to have to make in a long time. So you don't go out of here and leave your feelings in the courtroom. During the trial, it seems the state's changed its theory several times. Remember, they said, well, was he looking for help? Was it a voluntary encounter? Did he have mental health issues? A knock on the door, Mike Compagni said, it was consistent with the first-degree burglary. Wes's lip, was his lip bit? Was he struck? Did the gun recoil and hit him in the mouth? Well, if it did, why was blood right here? Remember, they asked one of the questions they asked was, could a gun have recoiled and hit him in the mouth? Okay, why was Kerrick's blood right there on the firearm? Ms. Postel asked a question of Wes Collins Ferrell, said, irresponsible people need protection too, isn't that right? Was he irresponsible or is he just innocent and looking for help? Lady Justice. Lady Justice is blind like she should be. You see the scales the state has to tip, and you see the sword. And the sword means the enforcement of the judgment. You are the judgment. You collectively as a jury are the judgment. Your verdict needs to speak the truth. You're the conscience of this community. Mr. Harris said a few minutes ago, who polices the police? Of course you do. You police all of us. Your verdict, and you police everybody, your verdict can't be based on emotion. It can't be based on fear. This case is not for the timid. And if the 16 of you that signed up for this, I don't want to say you knew what you were getting into, but as Judge Irvin called it, you were drafted to do this, and you served with dignity, with grace, and with courage during this situation. Your verdict must be sanctioned by your conscience and ratified by your reason and common sense. Folks, it's not reversible. You don't get a redo, you don't get a do-over, you don't get a mulligan in golf is you get another shot if you hit a bad one. You don't get a second chance. You don't get a second chance. You only need one reason to doubt you fulfilled your verdict. You have a duty, ladies and gentlemen, to deliberate with one another. But you don't have a duty to surrender your firmly held beliefs about this case. Long trial. 21 days. The search for justice in a trial like this has no shortcuts. Abraham Lincoln said the highest calling of citizenship is serving on a jury. And you know, for 21 days, Mike and I had the privilege of sitting here with Wes Kerrick. And if we've asked a question of you, you're in voir dire, or you're a witness question, that you thought we crossed the line, don't hold him accountable. Hold us. He deserves better than that if we've messed up. He deserves better if we've offended you at all. The verdict speaks the conscience. Go back there and find this young man not guilty. Let him go home and stand alone. Thank you, Judge.
Choices, decisions, and duties. Good morning, and I see that it's almost afternoon. I really appreciate that you are giving me your attention. I hope that you do understand, and I'm sure that you do, that this part actually is really important. The reason I'm standing before you now is because this is the first time we get to talk to you about what the law is. That's just the rule. Nobody in here made that rule, but that's the rule. Judge Urban's going to tell you what the law about this case is, and he's told us, so we get this opportunity now to explain that to you. And I'm going to do that. I want to start with first saying that, of course, the state has the burden in this case. We told you that in the beginning, and you remember, I'm sure, from your really lengthy jury selection that we talked about what reasonable doubt means. It is important, and that's why Judge Urban's going to tell you what it is again, too. That's the burden that the state has. It means using your reason and common sense to be fully satisfied and entirely convinced. It's not 100%. It's not 99, 98, 95. You can't put a numerical value on it. It is using that same reason and common sense you had when you walked through that door a month ago. The same common sense you have that you use every day with your interactions with people you know and people you don't know. They tell you something, and you observe them, you watch how they look when they're talking to you, the expression on their face, the tone of their voice. You evaluate that and you decide if you believe that. That's the same kind of reason and common sense you use in this case. And what the state has to prove to you, beyond a reasonable doubt, is that the defendant here, that defendant, is guilty of voluntary manslaughter. There are 3 elements to that crime, and that's what the state has to prove, those 3 elements. That is something that was not discussed in the last argument that you just heard at all. And I'm going to put those little 3 elements up there on the board in a few minutes. But I do want to take this time to address a few things that you just heard. Warriors, police officers in the United States are not warriors. Police officers are here to protect the community. They are not at war with the citizens in the community. That's not what we have here. Not in the United States, not in Charlotte, North Carolina. That's not what we have here. How many possible distractions could have just been brought in front of you? It did not discuss what the state has to prove. How many distractions? Why did Captain Campagna say that it's okay to deploy the taser? Well, he told you why. Because even if you took everything Officer Little and everything the defendant said, even if you believed everything they said, you could not use deadly force, but you could use everything less than that. That's why. Captain Campagna did not tell you this was a first-degree burglary. He said it was a burglary call. First-degree burglary actually requires that we prove what the person was intending to do, and that what they intended to do was to either steal or commit a felony inside. There's no evidence of a first-degree burglary here. Why did the state not call Officer Little? And I apologize, there may be a few things I don't even need to talk about that you guys have already figured out, but there are certain rules that we have to follow, like not talking about the law until we get to closing arguments, and like not calling witnesses that we know are not going to tell the truth. That's why we didn't call Officer Little.
Objection. What else? What's the state's reason? You see counsel seconds. Ladies and gentlemen, you just destroyed the last comments. Maybe said.
Officer Little's not credible. That's the state's position, and that's a decision, of course, that you get to make. And that's why the state didn't call Officer Little, because he's not credible. Why did the state not put in the 911 call and the CPI call? Because the defendant didn't hear those, and so they're not relevant. Because what's relevant is what the defendant knew when he got there. Why did the defendant put it in? Because it's not relevant, and then you would hear someone was really upset. The defendant mentioned that they could have arrested without putting on evidence, and absolutely that's true. Certainly. Maybe they should have. Maybe they should have. Because they called a psychologist who never met the defendant, who did some sort of testing that went through the mail, and decided that the defendant could go and be a police officer. And they called Officer Little. You saw how that went, and what he said happened. And I believe Mr. Warren just told you videos don't lie. Then they put on Dr. Rossi that told you what you already knew, which was there was blood, John's blood on the gun, and on the very bottom of the defendant's pants and on his boots, but that she couldn't tell you anything more about the rest of it, except that people couldn't be ruled out. They called Officer White, who told you that the defendant was trained, that someone who's running at you, even when you can't see their hands, is not a green light to shoot. They called Officer Sardan, who told you that people who smoke marijuana are the easiest people for him to deal with. They'll tell you anything you want to know if you ask them. Talk to you about this diagram that Dr. Owens drew, and he asked you, wonder why the state didn't ask him to draw a diagram, but you already know the answer to that. It's because Dr. Owens told you, when we asked him about that on the stand, that there were any number of different positions these people could have been in. That's why. The defendant asked him to draw one position, there were any number of positions, and he wasn't there. He couldn't tell you what position they were in. He could only tell you about the angles of the shot. I believe he just asked you how hard you would have to hit that door to put a dent in it. It's really heavy. And you can ask to see any of the evidence that you want to see. The judge will decide how or if that's going to work. But you can ask for any of that. That door has dents on the inside of it, too. Mr. Lauren just told you that this case is about drinking and smoking marijuana. Now, you know that's not what this case is about. And he told you that that video is not helpful to this case. Yes, it is. You already know that, so I don't need to dwell on that. This case is about the defendant shooting an unarmed man 10 times. That's what this case is about. Mr. Lauren just told you that maybe Jonathan grabbed the gun before he got shot. How in the world did that happen? That didn't happen. Even if you take the defendant's story as he tried to change it when he took the stand, no, that didn't happen. The defendant himself didn't even try to tell you that happened. Where are we with this? Grasping at straws and not talking about the law. That's where we are. He asked you, why didn't the state send Jonathan's blood off to be tested to some other labs for some other drugs? To be sure, if there were any other drugs in Jonathan, they would have found them and they would have shown you that. He asked you, did Jonathan kick the door before the wreck? These are not even reasonable questions. It's just a whole bunch of stuff to try to get you distracted from what you actually have to decide here, and I'm almost getting to that. But one other distracting question he asked you was, why companion? Why companion? Because he wrote the training? Because he's here and he knows exactly what that defendant was trained? Not just something in the abstract that lots of people are trained? No, he knows what he was trained. He wrote the training. He tried to suggest to you that there's some sort of obligation he had to testify the way that he did. And Mr. Lauren knows Captain Companion and he knows better. The state of North Carolina makes it a crime to kill someone by using excessive force. That crime is voluntary manslaughter. That's the case that we're here for today. Judge Urban's going to tell you about those three elements. If I can get this little projector thing over here to work, I'm going to show you what they are right now. For you to find, for you to find the defendant guilty of voluntary manslaughter, the state has to prove only three things. First, that the defendant killed Jonathan by an intentional and unlawful act. Intentional for voluntary manslaughter means that he purposely pulled the trigger. Voluntary manslaughter does not require any sort of specific intent to kill. An unlawful act, it's unlawful if it's excessive. Okay, so we'll come back to that one. Defendant's not contesting that he pulled the trigger on purpose, right? We got all that except for, we'll come back to the excessive force part. 2, the defendant caused Jonathan's death. He's not contesting that one either. He did cause his death. He shot him 10 times. He's not contesting that. 3, although acting in self-defense, the defendant here used excessive force. So what we see, the bottom line is, the defendant killed Jonathan. He pulled the trigger on purpose, and Jonathan died from the gunshot wounds. The defendant admits this. The defendant had the authority to defend himself with reasonable force. The state admits this. So the only issue that's really in dispute here at all is excessive force. Did the defendant use excessive force? He did. Nobody really wants to think that the police, those people who are charged with protecting us, makes bad choices, makes bad decisions, and doesn't fulfill their duty. But that's what happened here. The defendant shot Jonathan 10 times, and that was excessive, and that's voluntary manslaughter. The state's not contending that the defendant just woke up and wanted to go kill somebody, or that he intentionally tried to kill Jonathan. That would be murder. That is not what we're here for. We're here for voluntary manslaughter. What the state has to prove to you is that this was excessive. What he did, shooting Jonathan 10 times, was excessive. This is a sad case. The defendant was a police officer, not a bad guy. Jonathan was a guy wearing a teal shirt with matching plaid shoes and a hat. But that's not really what you're here for. What you're here for is to see that this was excessive force, and that you've seen over and over again. The judge is going to tell you that the only way the defendant could use deadly force in this case is if he believed that it was necessary, because Jonathan was a threat of death or serious physical injury, and that belief was a reasonable belief. Did the defendant even really believe that Jonathan was a threat of death or serious physical injury? Even if he did, that belief just isn't reasonable. Not on these facts. Not with this case. You saw that video. You saw how Jonathan walked up to the police. Judge Irvin will tell you that some of the factors you should consider are the size and strength of Jonathan to the defendant. Of course, you're going to think about the defendant's training as that goes into that, and the fact that he had 2 other trained officers there with him. He's going to tell you to consider the fierceness of the assault, if any, by Jonathan. If any, it wasn't fierce. Even when he started to move faster, if we call it running, moving faster, whatever it was, it certainly doesn't even look like a football tackle. Kind of like a prance or a dodge. You saw it. And if Jonathan had a weapon in his possession, because we certainly can't say that every time somebody walks up to a police officer, they have a weapon because the police officer has one and they might take it. That doesn't work. You have learned, just as the defendant did when he went through his training in Reali-Tea, when he did his additional training, and when he did his in-service training, that police officers don't get to shoot someone just because they walk up close to them and they might take their weapon. And they can't do that because they have no idea if they have a weapon or not. That situation Thompson talked about, and that didn't help him either. That situation Thompson and Brady talked about, that situation was different. Because in that case, the defendant and Thompson thought that guy was going for a weapon. They both reasonably thought that. That guy, first of all, was commanded multiple times to show his hands, and he wouldn't do it. And his hands were concealed up under his shirt. They both described him as hunching under like he was about to pull a weapon. That never happened here. The defendant didn't say that when he was interviewed. He didn't even say that when he stood up here on the stand and began to change his story. That's not what happened here. This case is a classic example of someone who's coming towards an officer so the officer gets to use force, but non-deadly force. If this was going to be anything, it was going to be a fight. Just a fight. And the defendant, like every other officer, doesn't have to wait to get hit. They can hit first. He could have used every single weapon he had. His personal weapons, his hands and his feet, elbows and knees, his OC spray, his baton, his taser. He could have used any of those things. Just could not use his firearm. Just because somebody walked up to him. Can't do that. That's excessive. In the defendant's own words, he started shooting at Jonathan when he was 10 feet away. 10 feet away. There's no indication, I'm going to take your gun. There's no swinging or grabbing for a gun. He's coming towards him and he's 10 feet away. Now, he got up on that stand and he told you he was 3 to 5 feet away. And he changed his story. But still, he's 3 to 5 feet away. He also changed his story when he got up there on the stand and he demonstrated for you and said that Jonathan kind of reached behind his back. He had never said that before. That is not what he told Detective Morales. Why is he doing that when he's sitting up there on the stand? It's almost time for you to go do your duty and follow the law. And you know, still, 3 to 5 feet away, reaching anywhere. He never told you he thought Jonathan was pulling a weapon. He never said that. He didn't say that. He said he didn't know one way or the other. Ladies and gentlemen, that's excessive force. If the police could shoot everybody who walks up to them, even within 3 feet of them, not knowing if they have a weapon or not, we'd have a whole lot more dead people. They can't do that. It's excessive. And about the last shots, when he's on the ground, the defendant said, told Detective Morales, his only fear when he was on the ground was that Jonathan was going to take his gun. His only fear. And you don't have to be somebody who thinks officers should necessarily drop the magazine out of the weapon. But if that was true, if his only fear was that Jonathan was going to take his gun, he could have discharged that cartridge. He could have dropped it right there, and then it wouldn't fire. And he knew that. He was trained that. Wouldn't even fire the one in the chamber. And then he could have fought. Then he could have gone hands-on with this man who was dying on his legs. If that was his only fear, he could have done that. And there were 2 more officers there who had all their weapons, too. And 2 more guns, if it ever got to that, but it didn't. The United States Supreme Court taught us in Graham versus Connor that the determination to be made is not what the defendant believed, but what a reasonable officer would have believed necessary. And you get to determine reasonableness. You decide that. You have 2 very important clues in this case. This case, the defendant wants you to think is a tough case. This is really not a tough case. It's a sad case, certainly, because of what happened, because of who the players were on both sides. But it's not a tough case. Excessiveness in this case is not tough when you're shooting somebody from a distance far away with no idea if they have a weapon or not. No reason to think they do. But you had 2 clues about what a reasonable officer would do, because you actually had 2 officers on scene. One of them deployed the taser. And the other one, even after the taser didn't work, was going to go hands-on. Neither one of those other 2 officers ever even unholstered their firearm. What would a reasonable person do? Go hands-on. That's the evidence in this case. You already have that information. And the defendant was not alone out there. Not only did he have his training, and he had a lot of training. He had all kinds of training about how to fight. Why? Because police officers have to fight. Is that a good thing? No. Should people do what the police say? Yes. But they don't always do that. He had a lot of training. He himself said that he was very competitive and very physically fit. He was trained to use his hands and his feet, his hands to punch, his feet to kick and trip, his knees and his elbows to strike. He had all that training. I showed it to you before. I'll show it to you again. What else did he have? Without some gloves on, so it's going to go first. He had a baton. He had a taser that it did not use. He had a flashlight too. OC spray. He had a radio. He didn't need that radio. You know why? Because he had 2 more officers right there with him too. This was not just the defendant versus Jonathan. Jonathan, an unarmed man who was shoeless. It was not just the defendant versus Jonathan. It was the defendant and all this. The 2 more officers. Stand up for me, please. We're taking the officers over. The defendant and 2 more officers, and all his weapons, and 2 more sets of hands and feet and knees and elbows, 2 more tasers, 2 more OC sprays, 2 more flashlights, 2 more batons. This was excessive. The defendant showed you a picture of his injuries. I really don't even want to show you this. And I apologize for doing it. But it's important. Because the only issue you have to resolve is excessive force. These are the defendant's injuries. And he had all this equipment, 2 more officers with him. And this is what he did to Jonathan. Ladies and gentlemen, that's excessive force. That is much more force than was reasonably necessary. The state has met its burden to you. The state has done its duty. Now it's going to be time for you to do your duty. You promised that you would follow the law. That's why you got chosen. Listen to the law as Judge Irving gives it to you. And then go back there and deliberate together. And follow the law. And do your duty. And find the defendant guilty of voluntary manslaughter.
Ladies and gentlemen, it's about 20 or so. I'm going to give you all a choice here. We can do 1 or 2 things. I can go ahead and give you the jury instructions and let y'all proceed, or I can let y'all go ahead and take a lunch break and we bring y'all back from the lunch break and give you the instructions. That's time, so y'all have a sense. What your preference would be.
What do you say? What now? What do you think? 45 minutes. Now.
We want to hear it now.
Want to hear it now? jury all the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give you to those facts. It's absolutely necessary that you understand and apply the laws I give it to you, and not as you think it is or as you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. The defendant in this case has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when the defendant pleads not guilty, the defendant is not required to prove his innocence. The defendant is presumed to be innocent. The state must prove to you the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or the lack or insufficiency of the evidence as may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. Ladies and gentlemen, you are the sole judges of the credibility or the believability of the testimony of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all or any part or none of what particular witnesses testified to on the witness stand. You decide whether to believe the testimony of any witness. You should use the same tests of truthfulness that you rely upon in your everyday lives. These tests may include the opportunity of the witness to see, to hear, to know, or to remember the facts and occurrences about which the witness has testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the witness's testimony is reasonable, and whether the witness's testimony is consistent with the other believable evidence in the case. Ladies and gentlemen, you are also the sole judges of the weight of any evidence. By this I mean if you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. There are two types of evidence from which you may find the truth as to the facts of a particular case, either direct evidence or circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts